Hello, everyone, and welcome back to SEC Roundup. My name is Nick Morgan. I'm the co-founder of ICAN, Investor Choice Advocates Network, and the host of today's SEC Roundup. I am delighted to be joined by two folks from AIMA, the Alternative Investment Management Association. We've got Daniel Austin, who is the head of U.S. Markets Policy and Regulation. Daniel, thank you for joining.
I'm happy to be here, Nick. Thanks for having me.
Thanks for coming on. And a regular contributor to this program, Suzan Rose, who is AIMA's Senior Advisor for Government and Regulatory Affairs. Suzan, thank you for joining.
Thanks for having me.
We are returning to a topic we've covered in a few prior episodes because there have been new developments. The issue is, and I'll let Suzan and Daniel go into more detail, but at a very high level, the issue is the definition of a dealer. That we're talking about a securities dealer, obviously, and this is the SEC's definition. And as we've talked about previously, one reason why this question is so important is because if one is deemed a securities dealer, all sorts of regulatory obligations then follow. So it's a decision that has consequences. So with that very general overview, Suzan, can you kind of bring us up to date? Obviously, AIMA has been following the dealer issue for a long time, and I know you have personally. So maybe just for those who don't follow it as closely, give us some of the highlights over the last couple of years on this topic, please.
Sure. Well, try not to nerd out too much about this. But
nerd
there are
out.
two threads. Oh, you don't want that. But there are two threads to this, as you well know. There's the dealer rule as well as the dealer definition litigation, and they're separate. They've been occurring in tandem for the most part, but let's just start quickly with the dealer rule. The dealer rule was proposed, there are two rules that were known as the dealer rule, was proposed in March of 2022. And it would identify certain activities that would constitute a regular business that required a person engaging in, say, certain liquidity providing activities to register as a dealer or a government securities dealer. It vastly expanded the definition of a dealer beyond what was well understood and accepted and abided by for nearly 90 years. So there was a lot of comment by AIMA and many others in the public in opposition to this administration. It's an administrative overreach. We identified the harm that this rule would do and rightfully questioned the SEC's authority in making such a change. We had many meetings with the commission and explained why these rules were harmful, unnecessary, and perhaps what alternatives might be appropriate to achieve their aims. But nonetheless, in February of 2024, the commission adopted the rules, or the dealer rule. It was downsized significantly, but it still vastly expanded the definition of dealer. And also included was this troublesome presumptive language, or no presumption language, which essentially gave them the ability to, even if you didn't fit within the definitions of the rule, deem you a dealer on a facts and circumstances basis. So AIMA and others were left with no choice but to challenge the dealer rule in court.
Okay, so the dealer rule then is in trouble in federal court. Maybe, Daniel, you could pick up the story from there. So what happens next?
Yeah, Nick, thanks. So we challenged the rule in federal court, Northern District of Texas, with two other associations, arguing that the SEC exceeded its statutory authority and really arguing that a customer is key and required to being a securities dealer. We cited the 90 years since the Exchange Act's passage for that support, and then certainly prior to the Exchange Act, what being a dealer meant in financial markets back in the 1930s and 20s. On November 21st of last year, Judge O'Connor in the Northern District of Texas ruled in our favor, striking down the dealer rule that the SEC had exceeded its statutory authority and held that a customer is required to be a dealer. So we were very excited about that outcome. On his last day as chair, Gary Gensler lodged an appeal to this rule, or to the ruling and out of the Northern District of Texas. That was to go up to the Fifth Circuit. Once the administration change came through and we saw Acting Chair Ueda assume that position, we put in a letter requesting that appeal be swiftly withdrawn. It was subsequently withdrawn by the commission, so we're very pleased to see that. And as of right now, that rule is no longer law that we have to live under. I think there's some clerical things that the commission has to go through to get it off of the books, out of the Federal Register, similar to how we saw with the private funds litigation back last summer when they went through the clerical process of getting it off the books in the Federal Register.
Yeah. Okay. Well, so that brings some finality to that track, as you described it, Suzanne, the track of the rule. Let's sort of and sort of this issue of customer being necessary for someone to be deemed a dealer. Let's back up and talk now about that parallel track, which was the SEC trying to expand the definition of dealer through litigation on a case-by-case basis. Can you bring us up to speed on that situation?
Certainly. Well, it's something that you and I have been discussing for a long time, and certainly we've been focused on at AIMA for quite a while. We became involved and very focused on this in 2022 with a case against Ibrahim Al-Magharbi. And that goes back to actually 2017. So we're talking not just the prior administration, but several back. And perhaps there were prior cases, but at the end of the day, Al-Magharbi is one that we put in as amicus. We put in briefs about, and our concern was what the definition that the SEC was using in deeming somebody a dealer, what that definition would mean for the industry. Now, it was different than what you saw in the rule, both proposed and finalized. It was much broader. And actually, really, you only had to buy and sell securities as part of a regular business to potentially be deemed a dealer. And who wouldn't be ensnared in that? So again, AIMA got involved in the Al-Magharbi case as amicus in 2022. And there have been, I think I stopped counting when it hit a dozen, but there have been upwards of a dozen cases similar to the case against Al-Magharbi, generally focused on small players, generally focused on convertible bonds. But at the end of the day, they were furthering this definition, this much broader definition of dealer in district and circuit courts around the country, and really many weren't watching it. So, and certainly everybody was watching the dealer rule, but this parallel was important because it gave a different avenue via litigation to define a much more broader term for who is a dealer. So in any case, I mean, you have what? We're now in 2025 and you still have active cases. There were two that were decided in favor of the SEC. Certainly they go back to a period before when we had Chevron deference. So there was much more sway with the commission's view on regulatory ambiguity, and the dealer definition would be one of them based on how the regulations were written way back. But all of that said, there's still several cases that are alive and kicking. One is Careborn Capital, which I'm sure you're aware. But AIMA has been involved net in these cases as amicus, pushing against this redefinition of who's a dealer on such broad terms since 2022. And right now, the cases do seem to be, for lack of a better description, falling apart. Certainly, the defeat of the dealer rule did not help the SEC's advancement of their view on an expanded definition. And while this is good, because we would hope that these cases wouldn't succeed in court because of the flawed definition, what's a bit troubling is as they drop away, there's nothing really to counter the two cases in which the court agreed or the courts agreed with the SEC's interpretation. So now we have a situation where we still have active litigation, and perhaps we'll see a final outcome, perhaps we won't. But we have two decisions at least that are left standing that actually support a broadened definition. So I'll leave that there.
Mm-hmm.
Just
Go ahead,
I
Dave.
would just add, Nick, to Suzanne's point. The interpretation that the SEC had in these enforcement actions was that any person in the business of buying and selling securities is a securities dealer. So you take that to its logical conclusion. That's any hedge fund manager, it's any pension, it's an insurer, it's your day trader. You go down the list. So there's really no limiting principle in there. And unfortunately, the 11th Circuit ruled in Keener and Almagarby that no, a customer isn't required there to really kind of have that limiting principle in there. There was some helpful dicta in Almagarby around investment advisors and private funds and the work they do, kind of juxtaposing that with what Almagarby was doing. Nevertheless, to Suzanne's point, I think there are at least 12 cases where they've pushed this theory. Almagarby and Keener, the furthest along, decided by the 11th Circuit. The next furthest along is Careborn, which is an 8th Circuit. We filed an amicus brief there earlier this month, and the SEC has asked for an extension there, and I think its brief will be due May 9th. And that's consistent, and Suzanne alluded to it, with what we're seeing out of the commission in terms of its posture or approach to some of these cases, where they're seemingly taking a step back and reassessing, this argument that they have pushed in these various cases. And that's something, again, that, we highlighted for Commissioners Ueda and Peirce during the prior administration of, not only is the rule a problem, but these enforcement actions are a problem. Commissioner Ueda highlighted it in his dissent to the rule at the open meeting. And I certainly think that those efforts that we've put in are starting to bear fruit in terms of what we're seeing now out of the commission as they approach these cases that are still pending.
Yeah, so that's a fascinating thing to watch them take the step back in these pending cases. I'm curious, Daniel, so let's assume hypothetically that the pending litigation gets resolved in some way. And then, as Suzanne pointed out, we will still be left with the 11th Circuit rulings on the books in Keener and Almagarby. What do you see sort of going forward in terms of what do we do next on this dealer issue?
Yeah, I think in a I guess law school fantasy world, I would have liked to have seen the dealer rule decision get appealed and go through the process. Maybe we work out a circuit split, goes up to the Supreme Court. We see if we can get 5 justices there to say that a customer would be required. I would like to see, like in a video game, if you could simulate it to see how that would play out. But I do think that, what we've seen in these enforcement actions that are currently pending, the SEC kind of starting to pivot away, is encouraging. Nevertheless, like you said, we do have the 2 opinions out of the 11th Circuit, and even some of these district court decisions in these cases where they say, no, a customer's not required. We agree with the SEC. So there is that unhelpful precedent there. Mm-hmm. So if we turn the calendar to, in several years to a new administration, and you have, the next Gary Gensler, and perhaps they come back and start pushing this, hyperliteral interpretation of the dealer definition again, right? And we're right back where we started. So I think that's why it's important that we have kind of been at the forefront of these efforts on the amicus side, and putting in these briefs where we can to really kind of hammer home the point that without a limiting principle to this interpretation, the harm that could accrue not just to the private fund space, but to financial market participants generally, would be very problematic for the industry.
Yeah, for sure. And I appreciated the amicus brief you all just put in the Careborn matter, which, as you said, is pending in the 8th Circuit. So in your sort of fantasy simulation world, I mean, I guess in one possibility world, the Careborn decision is issued by the 8th Circuit. I mean, it's possible Careborn could go to a decision, and maybe we get something more helpful than coming out of the 11th Circuit.
Yeah, I think it's interesting because there the SEC didn't appeal it. Careborn lost at the district court level, so he appealed. So the SEC can't withdraw the appeal like they did for the rule.
Right.
But I would anticipate that whatever they put in on May 9th in their brief may shed some light, or further kind of shed some light on where their thinking is around this. And then I guess it will ultimately be up to the court how they want to proceed on that.
Right.
I'll defer to you, Nick, on the exact appellate procedure there. I can't recall it from law school, however many years ago that was. But even so, we're still in a very interesting, phase here, even post-rule being struck down, where some of this enforcement will ultimately end up.
Yeah. Well, I guess we'll stay tuned for that brief on May 9th and see what the SEC's position is in Careborn. In the meantime, thank you both very much for coming on SEC Roundup. For everyone else, if you want more information about ICAN, go to icanlaw.org, and we will see you on the next SEC Roundup. Thank you.
Great. Thanks so much.